Kia ora koutou katoa, no mai haere mai. Welcome to the first episode of Legal Connection. This is Jesil Cajes. I am a lawyer based in Wellington, New Zealand. I specialize in family law, including wills and enduring powers of attorney. As you may know, we had technology glitch just a few minutes ago, but here we are. We are back live here at the studio. So I hope that you are with me today. Just really good to be with you, and thank you so very much for being with me this afternoon. So, yeah, I just want to greet some people, and I have some people to greet actually. And hi to the people of Kinanawan High School, including the Barangay Kinanawan officials headed by Chief Alicia Balonga, and of course the students of Municipal College. And hi to Cindy and Shane. Thank you guys for tuning in. By the way, guys, if you would like to comment, please feel free to comment on the comment section. Kia ora to you, Cindy Talainai Valo. And again, hello, wherever you are. And kia ora, ihoa, Mary, Lisa, Manuel. Anyway, let's dig in. So our topic tonight is, what is a will and should I have one? Right, that's a really important topic, isn't it? So, what is a will and do I need one? And we will be discussing tonight, what is a will? Who needs a will? And what is the requirements of a valid will? Dying without a will, what will happen if you die without a will? When to make a will? And can your will be challenged? And of course, questions and answers, very welcome. Just put it in the comments. I already received some of the questions and I have some answers as well, but feel free to actually just comment then. Alrighty, guys. So what is a will? A will is a legal document. It is binding, meaning it is enforceable by law. And that's your plan when something happens to you. That's your plan when you die. And that plan includes how your property will be divided. And if you have children under 16 years of age, who will look after your children? And they're called testamentary guardians. And your will as well not only talks about your property, not only talks about your kids, but as well as what happens to your body. Do you want to be cremated or do you want to be buried? And some gifts, whether you have a special taonga, your special heirloom that you want to pass on to your family, or it can also talk about some digital assets. At the moment, there is NFT, as well as what we call the cryptocurrency, who's going to own your digital assets. So that's a really important conversations when something happens to us. So a will is a legal document, all right? So it's enforceable. And a lot of topic that we're going to be talking tonight is about estate. Estate is just a legal term that refers to everything that you own. And that could be your jewelries, that could be your clothing, that could be your house, your property, your money, your bank accounts. That's basically the estate. So everything that you own when you die is called estate. So it's a legal word. All right. So if will is that important, is it mandatory in New Zealand? No, actually not. It's not mandatory. But if you die without a will, it can be really difficult for loved ones that are left behind because you die intestate. And I'm going to explain what intestate means in this context. All right. So dying without a will, for example, my friend Nico, he has 15,000 assets more, like his KiwiSaver, his bank account. He has 15,000 more assets. He didn't have a will. Therefore, his loved ones cannot get his assets straight away. They have to go to court and ask the court's permission. And not only that, the assets of Nico will not be distributed based on Nico would have wanted. The assets of Nico will be distributed based on the formula of the government. So it is the government who will determine how Nico's assets will be divided because Nico did not have a will. And when you think about the court, it's really expensive, right? It involves judges making decisions, it involves lawyers, and we know lawyers are expensive. And it can cause delay. So say, for example, Nico died, and then it may take until probably 9 months to 2 years before his loved ones can get his assets. So it depends on the process of the court. So it's already really stressful in this difficult time in the family, and you don't have to go through that court. And then another example is Judith. Judith does not have $15,000, but Judith has children under 16 years of age. Judith died without a will. Therefore, his children didn't have any guardians. So what is a guardian? A guardian um, is kind of like people who step in your shoes as a parent. So they have a lot of right. So they determine where your children are going to school. They determine where your children live. They determine what religion, what sort of medication, whether they receive COVID vaccination or all sorts of medication. So a guardian has so much rights when it comes to your children. And in New Zealand law, under 16 years of age, children need guardians, right? So Judith died. She had two kids under 16 years old, no will. Therefore, children had no guardians. Therefore, for the kids of a guardian, auntie must go to court, or whoever wants to be a guardian, they had to go to court, and then the court appoints a guardian. Now, the difficulty of that is the court may not choose Judith's choice, that it could be somebody else that the court might have chosen. So that's really quite difficult. So again, reviewing it, intestate means it involves court, lawyer, expensive, delay, and you have no control how the assets will be divided. Therefore, it's really, really stressful when you don't have a will. So again, Nico's situation, he had $15,000. He needs a will. Judith has children under 16 years of age. She also needs a will. What if you have assets less than $15,000? Then that means that your assets can be given straight to the king without having to go to court. All right, so let's go making a will. What do we need to make a will? First is we need an executor. I'll explain what an executor is. Then testamentary guardians, then beneficiaries, and then witnesses. So let's talk about executor. So executor is someone that you trust. Executor's role is they apply a probate. Now, a probate is a court order recognizing a will as authentic, meaning the will is real, it's valid, it's done properly, and also a probate confirms that the executor has the legal authority to deal with a deceased estate. So when you die, this is your will when you die, and this is all your promises. It's not enough to just bring this to the bank to get your money. What your executor would need to do is the apply probate to court. It can take 6 weeks, and then the court will the court will examine whether the will is properly done, it's valid, which I will explain how to do a valid will here. And then when the court is satisfied that okay, it's valid, it's formal, it's done properly, then they will issue the probate, and that can take up to 6 weeks. So that's the role of the executor. And the executor will control and distribute your assets. So say, for example, you said in your will that 50% goes to my spouse and the other 50 to my kids in equal shares. So that's the role of the executor, making sure that your wishes are adhered to. And then for you to be an executor, they have to be 20 years old, and they need to have they need to have a sound mind. And it doesn't have to be someone outside the family. It could be your children. It could be your spouse. Normally, that's what happened. Or it could be someone that you really trust. You don't want an executor that would run away your money, right? So you want someone that you trust that has, that ability to actually follow your wishes. Next, guardian. If you have children under 16 years of age, again, that's really important, because when you die, both of you die, the parents, your children need guardian for them to be able to enroll in school. And the guardian must be 20 years old, and they have to be someone that has the best interests of your children in their heart. So it could be your family member, it could be your neighbor that you love, that you trust, or it could be the godmother or the godfather. Depends really, but it has to be someone that know your children, that make sure that your children that make sure that will look after, or not necessarily look after, that make sure that will make decision for your children. Alrighty. Okay, thank you guys. If you have some questions, let me know and comment, and I will definitely I will definitely answer them. Beneficiaries. Well, beneficiaries, who will be your beneficiaries? How am I going to divide my will? So that's a really valid question, right? So beneficiaries could be your spouse. In New Zealand law, whatever happens during the relationship is a relationship property. Therefore, your spouse is entitled, the default position is 50-50. Your kids, your children, if you have children, they must have a your children must have a you have a moral obligation for your children, and anyone you made a promise, or you can even leave it to anybody, charity, something like that. But and independent witnesses, hmm, um you need two independent witnesses, and the witnesses must not be your beneficiaries or executors, and they have to be anyone over 18 years of age. Alrighty. I just had a feedback that I took too much. I took too fast. So let me know how I'm getting on. Alrighty. Okay. So requirements of a valid will. So this is an example. Look, signature of testator. I'm just gonna show it properly. So there you go. So John Smith, that's his signature, and he has two witnesses there, and the witnesses, put their names, their full name, occupation, and where they live. Also, it's important as well for a will to have no pressure, making sure that you're not pressured to do it, and you have legal capacity or sound mind. So another important consideration really is when you are old, right? Say 70 years old, as a lawyer, if someone comes to me and say, I want my will changed, and the will is quite a big departure from actually his previous will, saying, I want my will to be changed and I want to give everything to my new girlfriend, leaving out his children, then I will have to make sure that he has legal capacity or sound mind or nobody pressured him. So that's one of the requirements of having a valid will, because a will can be challenged, right? So now, again, a will needs to be in writing, signed by you and two witnesses, no pressure, and must have a legal capacity or sound mind. So these are the requirements of a valid will. Okay, the next one is, who can make a will? Right, who can make a will? If you were born in 2005, then you can make a will because you would have been 18 years old by now. Any 18 years old or over. If under 18, they must be married or in civil union or de facto relationship. And of course, they must have a sound mind or having the legal capacity to think and to make decision. Right, when to make the will? Well, now is the time. If you were born in 2005, right? Or you have children below 16 years old, you have assets of worth $15,000, you have life insurance, which I will be discussing very shortly. If you get divorced or you've got separated from your de facto partner, then you can actually, you may change your will. Or if you get married or entered into a de facto relationship. So these are some of the things that you have to consider when making a will. So if any of this fall on you, then I think you should make a will. Now let's talk about life insurance and will. So a lot of migrants, especially Filipinos in New Zealand, have life insurances. And it depends on the ownership of the life insurance, whether you need a will or not. But this is an example, okay? So an example is life insurance. Say I am the owner of my life insurance, example, and therefore I paid for my life insurance. I'm the owner of my life insurance. Therefore, when I die, the benefits will go to my will. And if I don't have a will, then my beneficiaries will need to go to court. However, if I have a will, then it have to go through my will. Therefore, it will be easier. So what it means that if you have a life insurance and you own a life insurance, then you must have a will. Otherwise, the insurance companies will not pay off, right? Now, there are also other types of will. There are also types of insurance. There's joint ownership. Example, John and Mary are joint owners of life insurance. John pays the insurance. Mary and John are the owner. When John dies, Mary will own the insurance. So the surviving spouse will own the insurance. Therefore, it bypasses the will of John. But Mary must have a will, because if something happens to Mary, then, you know, it will be hard for Mary, or for Mary's children, not to inherit what she has. Okay. When should I change my will? So I think a will is not a forever document, right? A will is not a forever document. You can change at any time, because life happens. You get divorced, you get separated, you get married, you have another child, one of your executors passes, or guardians passes, or any other significant event in your life. So you must change your will. Next, can your will be challenged? Yes, your will can be challenged in four ways. One, if it's an invalid will, so it's important to have an expert looking at it. Two, it can be challenged through the Family Protection Act 1955, which I will explain shortly. Three, it can be challenged through testamentary promises or relationship property. Now let's explain that. So your will can be challenged if your will is not properly signed and witnessed. One example would be, I am a wife, I ask my husband to witness my will. That cannot be, because a witness must be independent. So your will is invalid. Therefore, you'll have, you have to ask the court to declare it valid, which takes time and very expensive. Another way to challenge a will is Family Protection Act. What does it mean? For example, our friend Nico has two children, John and Mary, from his ex-wife. Nico remarried after his ex-wife passes. He left all his estate to his new wife, Martha, and did not make any provision for John and Mary. Therefore, Nico and Mary, being the children of, not actually, therefore, John and Mary, sorry, it's not Nico and Mary, I'm correct. John and Mary can challenge Nico's will, because under New Zealand law, you have, or we have a moral obligation to provide for our children. So we must provide something for our children. Otherwise, our children can challenge us if we don't provide for them, or we lift them out completely in the will. Next is a promise in exchange for services. So example here is Auntie J and John are neighbors. They're not even related. They're not cousins, right? They're not cousins. They are not blood related at all. And then Auntie J promised to give John $30,000 in her will when she dies, in exchange for John mowing her lawns fortnightly. And John mowed the lawns for 3 years, religiously, fortnightly. Auntie J died. Her will did not provide John as she promised. John can claim Auntie J's estate. Therefore, John can challenge Auntie J's will. Another one is relationship property. Say, for example, Judith and Ruth were in a de facto relationship for 5 years. They bought a house together and many other things together. They shared a life together. And then Ruth suddenly died. Ruth's will did not provide for Judith. Nothing. Ruth just gave it away to someone else. Therefore, Judith can challenge Ruth's will, because under Relationship Property Act, they have a house together. Therefore, it's a relationship property. Therefore, Ruth or Judith can has the right for a 50-50 division. Right. So our key takeaways now is wills are legally binding. They are actually formal documents that require us to plan when something happens. And that plan includes how our assets will be divided, who looks after our children after we pass, how, what to do with our body, whether we want to be cremated or buried, or if you have some digital assets like NFT or crypto, who owns it. And also, will also can determine whether you want to give gifts to charities, or you want to give special tauna to your family member outside, not necessarily your children. And then if you die without a will, your hard-earned money may go to IRD if no one claims. So that's really tough and sad. If you get married, your will becomes invalid. Wills can be challenged if not done properly. So it's really important to have legal advice. And wills are not expensive, right? It's not expensive at all. It is way more expensive to to have no will. The risk of having no will is really high than having a will. Okay, so questions and answers. So if you have some questions, feel free to actually type it in. Again, Arohamai guys, the one that I have, there is a bit of a glitch of technology right now, so I just want to say Arohamai. But if you have some questions, please let me know. Okay, Mary Lisa, thank you for your question. I'm just gonna show it around here. Mary Lisa, does debt come out of the will before it's released? Absolutely. So everything that you owe, taxes, deeds, will be paid before your estate will be divided. So thank you for the question. Beautiful question. Thank you very much. Okay, next question. Who has question? There have been some horror stories about strange parties challenging a will after someone passes. How can we be sure that the will be upheld and not challenged by some malicious individual? Shane, there's always a risk, even if you consult a lawyer, that your will can be challenged. However, that risk can be minimized if you have legal advice, if you consult people that are experts in will making, because these people, these experts, can show you the holes, the path holes, can show you the risks. And at the end of the day, it's your decision. But I think from our experience, the risk of it being challenged can be minimized by seeking legal advice, especially if you're talking about millions and dollars of assets. So that's, again, I share with your sentiment, Shane. That's not good that your legacy will be challenged in court. So it's important that if your assets is over $15,000, you seek legal advice to make sure that you have done, it will be done formally, validly, and within the ambit of the law. So thank you, Shane, for your question. Right. I have some more questions here. Please type in your questions. Who else has some questions here? I'm just going to check here on my Facebook. Right. I'm just going to... I have some questions here which are... which was given to me. One is in New Zealand, is it mandatory to have a will? No, not at all. But again, it's not mandatory, but the consequences are very, very high. Okay. Next, what are the advantages of having a will and advantages of not having a will before you pass away? Well, again, if you have a will before you die, you are in control, right? You exactly manage your affairs exactly the way you want it. Number one is you determine how your assets will be divided. Because when you die without a will, the government determines how your assets will be divided. The government will use the formula. So it's not your wish, but it will be based on the Administration Act. It will be based on the legislation. So it will be based on priority. I actually wrote an article. If you head to McWilliam Tyree Lawyers, I have an article. We wrote an article about who gets who when you don't, who gets who after, when you die without a will. So it's a matter of priority. You don't always probably want to agree that, this person will have it, but that's the way it is. The law determines how your assets will be divided. Of course, you have peace of mind, right? So I have a client that they are really close with their children's godmother, and they said, if something happens to us, I want X to look after our child, right? I want X to look after our child because they're very close. My child loves her, and that's really good. But if you don't have a will and you have children under 16 years of age, that person may not be chosen by the court, may not be chosen by the judge, and you don't want strangers making that decision for you. You want you to be making that decision for you and for your children. So it's important to really know that. Am I allowed to create a will by myself? How will it be legal? Did you mean how will it be valid? Yes, you're allowed to do it yourself. There's a lot of do it your own. And to be valid, a will must be in writing. Okay, it has to be printed, right? It has to be writing here. and then has to be signed by you. Okay, it has to be signed by you, but you don't sign it by you, just you. So you have to sign it in front of two witnesses, and we discussed already who these witnesses are. So they have to be, they are not the ones that in your. They have to be independent, meaning they are not in your will, and there is no pressure that that's what you really wish for, and you have a sound mind. Again, if somebody comes to us and they are maybe 80 years old, and then there's a drastic change of will, we probably need a medical certificate, that they have that mental capacity to do it. So what it means is you need to do it while you still have this mental capacity. Is it necessary, compulsory to have a lawyer to make a will for me? No, absolutely not. However, homemade wills, from our experience, are often open to being challenged or various difficulties. Because again, if you're talking about over 100,000 of assets, that's a lot of risk not to consult somebody that knows it, right? So you can do it as long as you know what you're doing. Right, I'm just gonna go back here to the questions. A really good question here. Thank you, Marie Rivera. Hi to Shane Hollis. How's Judith? I use Judith because I just love Judith. Okay, Marie Rivera. You can be assigned as a guardian to a dead person's children without knowing, in case you don't want to. Mary Rivera, I think you can say, for example, you've been assigned and you don't want to, you can actually refuse. That's why, for all of you wanting to appoint someone to be a testamentary guardian, you have to let them know. You have to ask their consent, because that could be exactly what you're talking about, Mary. That could be a difficulty, right? Because you can say, I don't want it. Who can be witnesses? Can this be other friends? Mary, of course, they can be your friends as long as they are 18 years old and they have mental capacity and they are not part of your will, meaning they are not beneficiaries and they are not your executors or testamentary guardians. What is the cheapest way to make a will if I don't have 15K plus in savings? The cheapest way to do it is probably do it on your own, but making sure that if you're not sure of it, then that's the time that you will have to seek legal advice. All right. So I think, or find a lawyer that is cheaper. Okay, thank you. Next question. Oh, this is a good question. Zaida Gloriana Dimoan. That's a really good question, Zaida. Thank you. Does it need to have separate will for husband and wife? Thanks. Well, there are two types of will, Zaida. There's what we call a mutual will. So that's one will for both of you. So one will only for Zaida and husband. Okay. And there's what we called mirror will. Two wills. Okay. Two wills. There you go. Two wills. One for husband and one for wife, but similar. So they mirror each other, right? And then, what's the difference between the two? Well, I think the court doesn't really like one will for both husband and wife. The reason for that is there's a recent case in 2020, I think, that the husband and the wife, they have only one will. The wife died, husband remarried, remarried. And when the husband remarried, he changed his will. He changed the mutual will. And what happens is, again, a will is not a forever document. You can't change it anytime. So the risk of having mutual will is your husband or the surviving spouse can change it. And whatever that is, then, whatever is the latest, then that would be upheld by the court. And it's actually the court said, actually the recent will is the valid will. So my advice, I'm not giving advice. So I think you need to think about whether mirror will or mutual will. It's not much difference, but again, the difference would be whether you only have one will, but the surviving spouse may change it. Whereas if you have a mirror will, independent will from each other, but maybe similar, if you die, then the spouse can't change your will, because that's your will. It's independent from the other. Okay, next question. How much do lawyers get for setting up the will after you have passed? Well, you don't need a will when you pass away. Again, you are called intestate, Mary Lisa. So you must do your will while you are still alive, right? Because no one will do it for you when you are gone, when you pass. In terms of the costs, I think if you do it now, then I would suggest that maybe, it depends on the firm. Some law firms would just say between 200 to 500. It depends on the complexity, really, of the case. I understand in our firm, we only charge per hour. So you only charge the actual work that we do. So we don't have a specific like fixed fee. So it depends on the complexity of your case. If it's really straightforward and simple, it may only take an hour to do it, right? So it's cheap. Next question from Aisha. Right, Aisha, what's your question here? Prenuptial agreement versus wills. Must they contain similar provisions? Like in my prenup, I have to clearly state which asset is mine and which asset goes to my partner. And does this mean that my will has to be drafted in a similar tone? Thanks. Well, that's a different topic, isn't it? So I think my opinion would be is if you have a prenup, then it has to be consistent with your will as well. Especially that in your prenup, if there is a provision there about how assets will be divided when you die, then I think it has to be consistent with your will as well. Next question. Right, many questions. Do those witnesses have to read what's in your will before signing? No, not at all. They just have to sign it. It's your signature. Thank you. Marie, more questions. Is there a particular digital way to store wills, or can we just store it via email? I would suggest have so they are. We'll talk about it later, Marie, because it's one of the questions as well asked by one of my, but by some of you. Do you have recommendations for more affordable legal advice on wills? We are affordable if you want to engage our services, McWilliam Tyree Lawyers, or you may have to ask some friends around what the charge rate are. Okay, shall we go to another topic here? Right, when should we make a will? Now. Now is that time. Now is that time to make a will. Please do it, especially when you have kids and you have assets more than $15,000. Do not wait when you're old. We don't know what happened in life. Look at what happened around us, Cyclone Gabriel, earthquake, and all that kind of thing. You just want to be really in control of what happened, right? We plan our holiday. We plan to go to America and Europe. We set those things. We have itinerary. And we know that death is an uncomfortable topic, right? But we know we're gonna get there. But my what I can say is we know that it's gonna happen. We know that death can happen anytime. So we must be prepared. So now is the time to do it. Otherwise, if you don't plan it right now, somebody else will determine how it's going to be divided. And that's your money. That's your kids. You don't want strangers to be doing it for you, right? So take control of that. How should all our assets belongings to be divided? Well, it really depends, right? It depends on your situation. I cannot give individual advice because this is not about advising. This is only information session. So it really just depends on your situation, right? It depends on your situation. So I can't tell you how it's divided when I don't know your situation. But of course, if you have a partner, bear in mind that a partner in New Zealand, de facto or married, they are entitled to 50% of your assets. And secondly, children, you have a moral obligation to provide for your children. How much does it cost to make a will? Well, it varies from simple to complicated. Again, some law firms charge per hour like we do, or some law firms charge fixed fee. So it depends really. So from our firm, it will be it ranges between 200 up to up to high end if it's really complicated. Meaning it requires time because we only charge per hour. What should I prepare before going to see a lawyer to make a will? A good question, really good question. Thank you very much. Well, you need to think about who would be my executor. I have 3 adult kids. They can be executors, right? Who can be my executor? Your executor should be someone that you trust, someone that would not run away your money. Guardian, if you have kids under 16 years of age, who can be my guardian? Who can be the guardian of my kids? Someone that you trust. How are my estate divided? How would I like it to be? Shall I give it in equal shares to all my kids? What about my wife? What about my husband? What about my partner? These are the things that you need to think. Beneficiaries. Again, who are the beneficiaries? What would I want with my body? Burial, cremation. So mind you, if you live in Wellington, it's quite hard to to find a plot here for burial. So you might have to consider other option. So yeah, and some cities probably will require like renting. I'm not sure. So think about burial, cremation. So that kind of thing. Can I change terms and conditions in a will? Yes. Again, a will is not a forever document. How much does it cost to do it? So there's so many questions about cost. Again, it depends on the complexity. Simple will, really cheap. And is there limited changing times? No, no limit, as long as you have a sound mind, and nothing. No, there's no limit. It's your document. It has to work for you. Right. What happens if I and my spouse could not reach an agreement on how our assets belongings will be divided? Well, again, I think it goes back to Marie Rivera's question, that, or someone else has asked that question, I think Zaida. I think it goes back to Zaida's question that um, if you can't get an agreement, you don't have to agree, right? But think about making sure that the Relationship Property Act, again, if you are in a de facto relationship or marriage, then you have to think that, oh yeah, my other half is entitled to 50% of what we own during the relationship. And if you can't agree, again, it will just go down to what you wish for your own, like, yeah, what you wish for your own. And I've discussed already mirror versus mutual will. So in that case, I would advise to seek. I would recommend to seek legal advice. When should I review my will? Every 3 years, or major changes in your life? So every 3 years. That's our recommendation, because we don't, like, have a look, read your will. Okay, after 3 years, it's still the same. Oh, actually, my executor already died, so I need an executor, therefore I need to review my will. Oh, actually, I don't think I'm gonna give $15,000 to Cancer Society. I'm gonna, or to other. I'm gonna change it. So these are the things that you may have to consider. So make sure that your will reflects your current intention. Okay, thank you for this question. What is enduring power of attorney? Enduring power of attorney is a legal document which sets out who can take care of your welfare. That's, referring to your personal welfare, or property or financial matters if you lose mental capacity but you are still alive. So enduring power of attorney is another important document which we will discuss in the next episode. Okay, we're gonna discuss it in the next episode. So enduring power of attorney um, is a document that you need, but when you are still alive. So the difference between a will and enduring power of attorney is will only kicks in when you die. So this will only kicks in when you die. That's why you can change it for as long as you want it. Doesn't have any power for as long as you live, right? I'm still alive. I can change my will anytime I want. But the enduring power of attorney kicks in only when you are still alive. Say, for example, something really bad happens to you, accident, or something bad really happens in comatose, or you could no longer make that decision, but somebody else has to make that decision, then that will be your attorney. Attorney, not necessarily a lawyer, but attorney is someone that you appointed to have the authority to make the decision on your behalf. And most doctors would do it, and especially those demented patients, before they can go to the rest home, they will need to have that enduring power of attorney. Do changes in my relationships affects the validity of my will? Absolutely, yes. Say, for example, this, okay? This is you. You are married. You made your will before marrying the love of your life. And then after marriage, that will becomes invalid, meaning it's gone. Therefore, you need a new will. And then another you separated. You made a will during your relationship, that will remains, and then you separated. Unfortunately, life happens, right? That will remains valid even after separation. So it's important to know this distinction, right? To know the difference. So when you get married, the will that you did before marriage becomes invalid. But when you separated, if you don't change your will, that will still remains valid. So it could be that whatever provision in there, ex-partner can still claim. Who will keep my will until I die? So I think this is a question from Marie, right? So you keep it in a safe place, okay? Or if you have a lawyer who does it, normally lawyers have a safe place to hold your will. It's important to let your executors know, because to know where to find your will. So I would advise, I will recommend really that, hey, I have a will, I put it along with my passport. So something happens to me, this is so and so. My executor, I let her know where my will is, and she knows exactly where to find it when something happens to me. And because there is no national register of wills, because it's a private document, right? You don't want people searching it online. Okay. All right. So I'm just gonna go back to Susanna. Susanna, thank you for your question. So attorney Jesil, I need two executors and two witnesses. Well, you only need one executor, Susanna. Yes, you need two independent witnesses. So you only need one executor, but it would be good if something happens to your executor, you have a backup. So I would recommend one executor and then another secondary executor. So I hope that helps. My. In the Philippines, we don't have a will. If I come to New Zealand and my husband is in the Philippines, do I need a will? Yes. Yes, definitely, my. You need a will, because if something happens to you in New Zealand, your body will be in New Zealand, right? So what would you like it done? And if you have some assets in New Zealand, say for example, you work here as a teacher, you have KiwiSaver, and then you have bank accounts, and you accumulated it over the years, and then your husband can't access that money over $15,000 without a will. So I would highly recommend to have a will, even if your family is overseas. Thank you. Shane, I'm just gonna go here. So we are now in question and answer, right? Just gonna go back here, guys. How are you feeling, guys? How are you doing? Thank you very much for tuning in. I know that there was some glitches, but I'm really happy that you managed to be here with me. So, is there benefit in setting up a trust to protect assets in conjunction with a will? Shane, I can't really give you advice when it comes to trust, because we don't do trust. All I know is your will must be consistent to your trust provision. Okay, so whatever you put in the trust, your trust deed, when you make a will, it has to be consistent in there. But I can't give you any information about the trust, because we don't do trust. Sorry, Shane. Sorry, Shane. What are the tax implications for inheritance passed on to the beneficiary? Ooh, good question. I don't think I know this. I know that one. I'm going to get back to you on this one, Shane. Thank you for that. Um, do executors need to sign on my will? No, not at all. Susanna, you only need three people to sign it. You yourself, the will maker, and two witnesses. The executors don't need to sign it, but again, it's important that your executors know that they are executors. Right? All right. Thank you. Next question. In a mutual will, is there a way that no one can change it? No, there's no way. Again, a will is not something that you can you must change it. Sorry, not you must change it. Anyone can change. The surviving spouse can change it. Susanna again. Do I need to take with me my executor and two witnesses when I will make my will in your office? Do I need to take with me my? No. If you make a will in our office, you don't need to bring anybody. You just come here, tell me what you want, and then we have two witnesses here in our office. So if you do it through us, it will be done here with all the witnesses, with all the requirements. So there's no problem at all. Okay. Any more questions? Um, Good question, Shane. Um, Good question. Sorry, I'm just gonna read it again. Can we assign a professional or a solicitor as an executor rather than a layperson? Very good. Yes, of course. Definitely, Shane. Um, you can ask. So, say for example, if it's a high conflict family or it involves a lot of businesses or all sorts of things, it is easier probably to assign a professional to do it, right? Because again, the role of executor is someone that will process a probate for you. They're the ones who will say, hey, so and so. So they are the ones who look at your will and say the beneficiaries are 1, 2, 3, and then they will ring, are you the beneficiaries of so and so? This is the will of Shane. Do that, do that. So absolutely, a professional can be done, and a layperson, any layperson can be an executor. Again, the advantage of having a professional is they can get it done. Um, they can get it done without having to worry about what needs to be done. And a layperson may navigate some difficulties in the legal system, but it's not impossible to do it if it's just a layperson. From our experience, if husband and wife or partners, they just appoint each other and then they have someone else do it. Also, another thing to consider, Shane, that if you appoint a professional, then they have professional fees, and that's something that you need to consider, because they will have to take out the professional fee from your estate. Right. Okay, Aisha. Wow, I'm loving this. How are you guys doing? Let me know in the comments how are we doing. In your experience, who are the three people or entities we must have copies of my will? Well, there's only you, Aisha. And I would imagine that if you do it through your lawyer will have a copy of that, right? Your lawyer will have a copy of that. And if you want to share it to someone, you can share it as well. But you don't have to share it to your executor. You just have to let the executor know that, hey, I left. If something happens to me, my will, I put it in my cupboard in the third floor of my house with a locker, and this is the code. You can tell them that, or you can just say, my lawyer is McWilliam Tyree. Just contact them. Okay. So I hope that is clear. Next question. Isa Diaz, is it really stipulated in the law to give 50% of your assets to your husband, or can you decide if you wanted to divide it equally to your children and husband? Well, that's the law. That's the default position, and that only becomes relevant, Isa, if there is a dispute, right? And the court's position would be what is the law, right? But if you are amenable or amicable with your husband, you can talk about how you are going to divide your asset, right? So some experience would say, okay, divide it equally to all of them, something like that. The only caution would be if you completely left out the partner with nothing, and then the partner didn't know about it, and they can challenge that. So that's the only thing. So again, the law only becomes relevant when there is a dispute. But if you agree, amicable, all fine, that's fine. Right. Good question. For enduring power of attorney, should I make at the time as the will? Yes, you should make it so that you don't have to go back and forth. For enduring powers of attorney, you really need a lawyer for that. It was asked before that do I need a lawyer to make a will? No, but it would be good to have legal advice. But for enduring power of attorney, yes, you need a lawyer for that. So it might be easier if you do it at once. If I'm assigned as a guardian without knowing, can I make the initial decisions? Example, who should take care of them instead schools to go to? Then reassign a guardian who agrees, or will a government agency have to step in? Well, if you are a guardian and you don't want to do it, then you can just say, I don't want to do it. But the fact that you are still a guardian, then yes, you must make that decision, unless you expressly say, I don't want to be a guardian. So the reassignment of a guardian will have to go through the court. What is the difference between having your will done by a lawyer versus having it done via public trust? Oh, I should have said. I guess it just depends. Public trust, they're not lawyers. Public trust, most of them are trustees, although they have lawyers. But if you do it with a lawyer, you do it with a lawyer. There's not much difference, I guess. So I'm not sure what's the difference. I haven't had my will done by public trust, so no comment there. I think the big difference would be how much does it cost, right? Right. Next question. Can you put executors of your will from overseas? Oh, Carmela, you just touched a really good point there, right? That's a really good point, Carmela. Now, you can put any executors of your will, anyone from anywhere in the world. But but you also have to consider the practicality of it. Say, for example, my executor is my father who lives in the Philippines, right? If something happens to me, the Philippines is not visa-free country, right? So my father would need a visa to make decision or to process a probate here in New Zealand. So it's not really practical. However, if you think that they can be here quickly, like for example, New Zealand, Australia, UK, that's fine. But there is no law that prohibits you from making from appointing someone overseas, right? But again, you just have to consider the practicality of it. And the question is, if they live overseas, who's gonna pay for their airfare? Who's gonna pay for their visa? All that kind of thing. Can I have an overseas executor for my will? Yes, you can. You definitely can have an overseas executor for your will, as long as they're over 20 years old. Shane, can you defer payout to your children while your spouse is still alive? Yeah, you can say, my children. Yeah, I think you definitely can. And under New Zealand law, the children will inherit your estate when they are 18 years old. Used to be 20, but now it's been changed. So you can defer it. But I need to know more information about why you're doing this and what's the driver behind it. It's important as well to ensure that the conditions of deferring it is not are not reasonable, right? Example of unreasonable conditions would be, I will not pay out my children until they get married, and so that's quite an unreasonable condition. Because again, what if your kids don't want to get married, or I don't want to give something to my kids until they finish university or a specific, university. But yeah, so those are quite difficult conditions to make. Alrighty, I think we have finished all the questions. Thank you, guys. I think I thought it would only last for like uh, um, 30 minutes, but hey, thank you very much. I'm just looking through all of these. Whether you have questions, I think that's all. But again, I just want to say thank you so much, everybody. If you have more questions, please let me know. So again, my name is Jesil. That's my email there, Jesil at McWilliam Lawyers.nz. You can check us out. Yeah, absolutely. So thank you, guys. I really appreciate your time, and I think you can actually watch this again. So it's such a privilege being with you here today, and God bless you all. And our next topic, if you have some topics that you'd like to discuss, so my specialization is family law, so anything about family, I think our next topic would be enduring powers of attorney, and that would be a really important topic. And if you have some topics that you'd like to discuss, then that's also fine with me. Just let me know. So this is our first episode of Legal Connection, and we are aiming to have this regularly. But with your help, we hope that we can have so much more discussion and so much more information. Again, disclaimer: this is not a legal advice. This is only and information. Okay, this is not legal advice, this is only information. I should have done this in the beginning, but anyway, thank you again, very, very much. I really appreciate you guys for tuning in today, and it is my pleasure to come back again. And if you have some questions or if you want your wills done, just email me, Giselle at mtlawyers.nz, and also follow me on Facebook page, Culture Connection. And I just want to read more comments here. Thank you, beautiful daughter. Seriously, you are awesome. Seriously, are awesome thing to do. So thank you, guys. Thank you very, very much. Amazing. Kakitiano, namihi. Everybody, have a great Sunday. Thank you for being with me. What a fantastic day to be spending time with you all. Thank you so much. And feel free to share this video if you think people will benefit from this information. Namihi.